5 of the Court of Appeals. My name is Gilbert Roman, and I'll be presiding today. To my right is Judge Dave Furman. To my left is Judge Nancy Lichtenstein. We have one case on the docket today, and that is People versus Camilletti, CA 2015 CA 1724. And I see that counsel are here and are set up, and I know that you're both versed in the protocol and procedures of the court, but if you have any questions, now's the time to ask. Seeing none, I would just remind everybody else that if you have a device that makes noise, to please make sure that it is shut off at this time, because it is very distracting. And also, I would remind counsel and everybody that this is being live streamed, and that it will also go into the archives. So with that, appellant, please remember that you have time for rebuttal, but it's up to you to make sure to save it, okay? We are ready to proceed then.
Good afternoon, may it please the court. My name is Jessica Pitts, attorney registration number 48932, and I represent Michael Camilletti. I'd like to focus on why the dog's sniff in this case was a search, why the dog's bark was insufficient to establish probable cause to search Michael Camilletti's vehicle, and why the good faith exception does not bar the application of the exclusionary rule. So to start, this dog sniff was a search. Traditionally, we don't think of canine sniffs as a search, and the cases explain why. So cases like Place and Esparza say that when the sniff can reveal only the presence of contraband, since you don't have a privacy interest in contraband, that sniff is not a search. So that would be just like a preliminary roadside test that would tell you whether a powder is cocaine or not. You have no privacy interest in that, it's not a search. Here, this dog is different. This dog is not just telling you that there's contraband in the vehicle. He'll tell you there may be contraband in that vehicle, or he's telling you there's marijuana, a constitutionally protected substance, in that vehicle. Since Coloradans have a legitimate expectation of privacy in the possession of marijuana, a dog trained to detect marijuana, when he sniffs a car, that sniff is a search.
Ms. Pitts, if marijuana is illegal federally, why is that not illegal contraband?
Marijuana status under federal law doesn't change this conclusion for two reasons. The first is the plain language of Amendment 64. Amendment 64 says, notwithstanding any other provision of law, the following acts are not unlawful. So Colorado voters, when they enacted Amendment 64, specifically considered the fact that marijuana is illegal federally and discounted that status when it legalized it under the state constitution. Further, you should read the Constitution in harmony. So if one provision of the Constitution specifically legalizes marijuana, you should read that in harmony with Article 2, Section 7 when you're determining Fourth Amendment questions.
And did the state argue preemption in this case?
I don't believe the state is relying on preemption in this case. Even if it were, this case is not barred by preemption. Preemption is where you have a positive conflict. So if state law required something that federal law prohibited, you might have a conflict there and there might be preemption. So to compare to Kraus, which is a case that the Colorado Supreme Court determined a part of the medical marijuana amendment was preempted because it required law enforcement to distribute back, if it had seized marijuana, it required law enforcement to distribute that back to the person. So because Colorado law required that distribution, which is something that federal law prohibited, that was a positive conflict and there was preemption there. In contrast here, state law merely allows possession for marijuana. It doesn't require it, so there's not that positive conflict. And further, the federal law couldn't make Colorado criminalize marijuana. We're dual sovereigns, and Colorado has no obligation to either, the federal government can't require the Colorado legislature to criminalize marijuana, nor could it require Colorado agents to enforce federal law. So turning to why the dog's bark in this case didn't establish probable cause. So probable cause exists when a person of reasonable caution would believe that contraband is present. and common sense is the touchstone of any Fourth Amendment question. So would a Coloradan of reasonable caution believe that they have a privacy interest in something that the Constitution tells them that they can possess, that the state informs them they can drive with, and that the state makes a lot of money in taxes on? I don't think a reasonable Coloradan would believe that legally possessing under an ounce of marijuana should give rise to a full-blown vehicle search. So further, Amendment 64 divests jurisdiction from police officers to enforce medical marijuana crimes. So I think that lends support to a Coloradan believing that they would have a legitimate expectation of privacy in possessing marijuana. And further, Coloradans rely on the fact that at the time of this search, the federal government was not enforcing the Controlled Substances Act with regard to minor possession of marijuana crimes.
Ms. Pitts, let me follow up with another question. So under Colorado, it's persons under over 21 years of age.
Correct.
And so is a police officer required to then, once they see the ID of a driver or passengers, determine whether they're of age to determine whether they can do a dog sniff?
So I think a good way to look at this is to compare it to alcohol. So Colorado voters, when they enacted Amendment 64, specifically said that they wanted it marijuana taxed and regulated just like alcohol. So the analogy here would be if we trained dogs to detect alcohol, to sniff cars, to make sure that if alcohol was in a car, that it was in a closed container, that the driver was over 21, and that it was legally purchased, that it wasn't moonshine, for instance. So I don't think that that would be reasonable under the Fourth Amendment or the Colorado counterpart. I think that we would think of that of that search as unreasonable. So, and I don't think that simply because there are certain illegal uses of marijuana. So there are possible innocent explanations for the dog's bark. When the dog sniffs and he barks, he's telling you there's marijuana in that car or there's a number of illegal substances. So when that dog barks, he's giving you ambiguous information. And so the level of ambiguity is going to rise and fall with the likelihood of this innocent explanation. So marijuana is extremely prevalent in this state. It's a $1.5 billion a year industry. So if you assume that an ounce goes for $200, that's 7.5 million ounces being sold per year. So that's greater than the population of Colorado. So the chance that any car that's stopped for a traffic violation might have legal marijuana as opposed to ecstasy or heroin or anything else is very high. So because the level of ambiguity for this fact, this dog bark, is so high, there need to be a number of other facts that are going to sort of disambiguate that fact or to give it context or explain, to make you think that the dog is barking, that the dog bark was caused by something illegal, not something legal, when that oftentimes is going to be the likelier explanation. So to compare to Zuniga and Cox, which are Colorado Supreme Court cases that looked at this, they said, well, the dog's bark can be considered under the totality of circumstances in a probable cause determination. But the facts in those cases showed significant indicia of criminal behavior. So in those cases, there were divergent or inconsistent travel plans. One case, there were 2 cell phones, which is indicative of trafficking. In another case, there was the heavy odor of marijuana. And in both cases, there was extreme nervousness. So those facts taken together with the dog's bark would lead a person of reasonable caution to think that something illegal is going on. Now, looking at the dog's bark in isolation, that fact alone, if there's nothing else like the facts similar to Zuniga and Cox, is just too ambiguous to give you enough to support a probable cause search of a vehicle.
So I take it that that's part of your response to the second pre-argument question that went out about probable cause then?
Yes, Your Honor.
Okay, great. Then there's still the first question, which I take it you're going to get to next.
Sure. So if this court agrees that the searches were unconstitutional, the good faith exception can bar the application of the exclusionary rule if law enforcement were relying on judicial authority that's directly on point. That's not the case here. The judicial precedent was not directly on point. As I mentioned before, the dogs in those cases, and I'm referring to Esparza and Place and Harris, the dogs in those cases could alert only to contraband. So because this dog could alert to non-contraband, it would be unreasonable for a law enforcement officer to rely on those precedents after the passage of Amendment 64. So it would just be objectively unreasonable after the Constitution changed for a law enforcement officer to then rely on cases that are no longer on point because marijuana is no longer contraband.
So, under your approach then, does the state need to take dogs like Kilo out of commission and start retraining for dogs that don't alert to marijuana?
I believe that's the simplest solution to this problem. That's what other states who have legalized marijuana have done. Certainly these dogs would still have uses perhaps around schools or near the borders to catch interstate trafficking, things like that. But in the usual case, I would submit the better practice would be to train dogs only on contraband. If there are no further questions at this point, I'll reserve the remainder of my time for rebuttal.
You have 5 minutes, 27 seconds. Thank you.
Good afternoon, Your Honors. My name is Joseph Michaels, attorney registration number 40403. I'm here today on behalf of the people of the state of Colorado. I'm going to go right to your questions and answer them in the order that I've received them, and then depending what time is left or if this court has further questions, I trust you will direct me accordingly, and I'm happy to respond to anything in these briefs. I want to turn to the first question, the question that McKnight did not address, whether the good faith exception to the exclusionary rule applies. The people's position is that, yes, the good faith exception allows the search in this case for at least 3 reasons, and there are additional ones that are related to that. The first is that case law at the time of the officer's stop was highly suggestive that phrase is a little questionable, but the case law suggested at the time that the dog sniff by itself not only was constitutional under the Colorado Constitution, but also established probable cause to search. The second reason is that the exclusionary rule is designed to deter flagrant police misconduct. Here there was no misconduct, let alone anything that would approach the definition of flagrant. And the third one, third key point, is that there simply would be no deterrent effect to excluding the search at this time. Turning to the first of those subpoints, I want to talk about the cases that were sort of governed the framework at that time. And the ones that we have to put aside do help illuminate sort of the confusion and ambiguity afterwards. But the cases that were really in effect at the time were Esparza and Mason. And Esparza was a March 2012 case, so it did predate Amendment 64. But what it did is it explicitly said that a dog sniff does not impact a privacy interest. And that dog sniff then, because it's essentially walking a dog around like free air around an area, the dog is just passively taking things in, and so it doesn't implicate a constitutional right or become a search in and of itself. Something I think that's particularly relevant to this case about Esparza is that Esparza came out of that jurisdiction. It was this exact same district court judge. It was the exact same situation where you had a dog sniff that had been suppressed at the trial court level and came back. So the message to that trial court, the message to that officer was the dog sniff does not impact a privacy interest.
So, Mr. Michaels, what is the message to that officer and the court from Amendment 64?
The message is muddled, quite honestly, because Amendment 64 is not a broad blanket allowance for marijuana. And that was so I mentioned there were 3 key points. Amendment 64 is sort of an ancillary point that governs everything. Amendment 64 has a number of very specific prohibitions, regulations, and directives to establish a comprehensive regulatory scheme. It's not, Colorado has given a blanket allowance for marijuana. It's Colorado has given specific discrete ways that marijuana can be legal. And I would call this court's attention to Article 18, Section 16, Sub 3 and Sub 4, which talks specifically about separate sections that lawful use of marijuana state shall not be a basis for seizure or forfeiture. What it doesn't say is it shall not be a basis for a search. And because of the comprehensive nature of Amendment 64, the absence or the omission of that phrase cannot be read in isolation. What that says is, consistent with the policy in Amendment 64 of protecting the public and protecting the sort of the state's rights, and I'll get to the drug trafficking part and general protection of the public in a minute, but taking keeping that word search out of Amendment 64 suggests to officers that it still can form the basis for a search. You just can't seize property, marijuana, as long as it's being used for a constitutionally permissive way. So less than 1 ounce over 21 years, not being sold wholesale, et cetera.
Well, so looking at the Esparza case, and the premise underlying it was that the non-search, the dog sniff, would either uncover illegal contraband or the absence of illegal contraband. So since Amendment 64 does state that a certain amount possessed by a person over 21 is no longer illegal contraband, does that change the state of the law despite what you're referring to as far as the other article of the Constitution?
Excuse me. It changes the state of the law in that it changes the analysis, but it doesn't change the message to the police officer at that time for the purposes of the good faith doctrine. And the reason why is because of the subsequent case, Mason, which was decided in 2013. And that case explicitly reaffirmed, even post-Amendment 64, that walking a trained narcotics dog around a car does not implicate either the federal or the Colorado Constitution, Article 2, Section 7. So the message is consistent that we're reaffirming, and Mason explicitly reaffirmed Esparza even post-64, and retain that same message to the police officer that a dog sniff is not a search. You are comporting with the Constitution. You are comporting with the state of the law at the time. And then post the search, we have Zuniga, Cox, Kraus, and even Coates to a certain extent, Coates versus Dish Network, they all give this global idea that the courts of Colorado, the Colorado Supreme Court, are taking a very narrow, very direct view of what's going on in the state of marijuana and how we regulate it. And they repeatedly say, Cox and Zuniga particularly say, a dog sniff still can establish probable cause. It still is a factor. And Zuniga even calls out that the dogs can still be trained on other things and it can still amount to probable cause. So both before the state of the law with respect to good faith doesn't tell the officer that he cannot do that search or that it's unconstitutional, and the state of the law afterwards confirms to him that the courts just haven't figured it out yet.
Mr. Michaels, I'm sorry to interrupt. I needed some clarification.
Sure.
You're talking about a dog sniff by itself when the dog alerts can establish probable cause?
Yes, I am.
Okay.
And the authority for that is the Florida versus Harris Supreme Court case, which says that dog sniffs alone can't establish probable cause. Now, I'll grant that the marijuana does change that analysis a little bit, but at the time that this dog was conducting the sniff and this officer was controlling this dog to conduct the sniff, that was the state of the law because it had been specifically approved of in Mason.
And you think that's what Zuniga and Cox are holding?
I don't think they address that issue, but I don't think they reject that issue either. Zuniga and Cox have ancillary considerations and additional behaviors that rise to the level of probable cause, but it doesn't say we disagree with Florida versus Harris or we think the Colorado Constitution requires more. Rather, Mason and Esparza both went out of their way to say the Colorado Constitution, Article 2, Section 7, does not require more compared to Amendment 4, the Amendment 4 of the federal Constitution. I want to talk a little bit then about the purpose of the exclusionary rule in terms of deterring police misconduct, because that, I think, cuts to the heart of the reasonableness of this search and the reasonableness of the trial court's wrestling with this idea of what's a trial court supposed to do in this situation. And the Supreme Court case of Herring explicitly says, we look at whether a well-trained officer should know or reasonably have known the search was illegal. And from what we've talked about, there's not really a question that the officer thought he was doing what complied with the law, especially in light of those directives. And so Herring then goes on to say that the exclusionary rule is based on looking at the flagrancy of the misconduct. And here, there was no misconduct. The officer showed, the canine officer showed up at the exact same time, within a minute or two of the initial traffic stop, while the officer who had pulled over Mr. Camilletti was still filling out the paperwork, still running his license, and he conducted a sweep very carefully. We know that this dog was very well trained. It had passed the certification with flying colors multiple times. And so this officer was clearly doing something that is essentially a routine to the area. And I would add that Moffat County is northwest corner of Colorado, closer to the border, where drug trafficking and crossing state lines can become more of an issue. It's also a county that deals with a great deal of methamphetamine. And I would highlight to this court that that's what was found in this case. There wasn't any marijuana, it was methamphetamine. And there's no question that Mr. Camilletti had no reasonable expectation of privacy in that methamphetamine. Turning to the third point, there's no deterrent effect at this point to excluding this search. And the reason I say that is, first of all, the message that McKnight sent is that the law has changed. So dogs and district and sheriff's offices across the state are adapting to that. So the deterrent effect to this officer has already been expressed because this is, in fact, the same officer and the same dog as from McKnight. On top of that, it's not, as previously just talked about, this officer didn't act flagrantly in any sort of misconduct, so we don't necessarily need to deter specific bad behavior out of this officer. This court is expressing to this officer, look, the law has changed. And so what you did then was okay, but under the law now, it's different, and so you have to retrain your dog, retire Kilo, whatever it might be, in order to comport with the search.
Let me ask you this, and this is moving forward a little bit. And suppose for purposes of this question that we were to conclude that a dog sniff is a search under the Colorado Constitution. What evidence of reasonable suspicion of criminal activity would there be?
Certainly. I'm glad that you jumped me to that point because I didn't want to neglect that. There are a couple indicia of reasonable suspicion here that is, in fact, quite different. And I would first note that the dog sniff itself is constitutional. The question is whether there is reasonable suspicion or probable cause to get into the car because of the dog sniff. Because it's a dual framework. The first is the sniff, and the second is what does the sniff allow you to do. And here, unlike in McKnight, we have a defendant who is a prior methamphetamine user. In McKnight, it was the passenger who had very little to do with the situation in total. Not only was he a known methamphetamine user, but both of these officers, not just the officer, I can't remember the one, but not only the officer who pulled him over, but the officer with the canine had been involved with a previous dog sniff that had resulted in methamphetamine being found on this defendant.
How long previous to this case?
That I don't know. The record didn't reflect that, but it's.
So it could be years?
Months? I don't think so. From the context, it sounded like it was much more recently, but again, that wasn't in the record. But that occurs.
The record referred to it being 3 years ago.
Oh, thank you.
Okay.
Thank you for that clarification. I must have missed that. Anyway, that's at the transcript of 420-15, pages 9 and 15. But these officers knew this particular defendant and knew that he had problems with methamphetamine, which, as this court knows, is a highly addictive substance. and knew that he had transported it in his car before. We also know that dogs aren't required to be foolproof, and so even if this dog incorrectly alerted, that's still just a consideration in terms of the totality of the circumstances. And as the Supreme Court and the U.S. Supreme Court and our Supreme Court have made clear repeatedly, ambiguity and possible innocent explanations do not reject this idea of probable cause. They just are ways of contributing towards it in sort of the totality test. I would also note, and I mentioned this in passing in the brief, is that there was no obvious smell of marijuana. And at first blush, that sounds bad. But then you think about it, and in Zuniga, you had this overpowering smell of marijuana. So clearly there was marijuana in the car. Here, we have a defendant who said, no, there are no drugs in the car. You have a dog who's alerting, and there's no smell of marijuana. The conclusion to that is it's one of the other 4 substances that do not give off smells that are readily identifiable to the human nose: ecstasy, cocaine, heroin, or methamphetamine. In the very brief time I have left, I want to highlight, I think, what are 3 cases that really sort of crystallize this idea of the good faith doctrine. And that's Illinois versus Kroll. And in that case, there was a system of warrantless searches based on a statute that was subsequently found unconstitutional. And the Kroll court basically said that the issue is to deter police misconduct. The origin of the law is not the focus on the good faith rule. It's making sure we deter police misconduct. The second one is Davis, which of course applies the good faith rule to the Gant versus Arizona case. And then of course Hine versus North Carolina, which says that a reasonable mistake of law can render an illegal seizure legal under those conditions. And so I would ask that you affirm.
Great, thank you, Mr. Michaels.
Thank you.
And Ms. Pitts, you have 5 minutes, 27 seconds left.
So I'd like to start with good faith. The good faith doctrine is not going to save this search. So you'll go to good faith if you find that the searches in this case were in fact unconstitutional. And if that's true because marijuana is not contraband, then it would follow that the cases cited by the state simply don't apply to this case, where the dog is not simply alerting to contraband, he's alerting to contraband or a constitutionally protected substance. I'd like to also touch on the other facts mentioned that the state's relying on to establish probable cause. So it's primarily that Mr. Camilletti was a prior drug user. I think the cases are clear that prior drug use is not enough to establish probable cause, even in addition to a dog's bark. McKnight is instructive on this point. And the policy here is simple. If every former drug user or former criminal, if that's enough to give you probable cause to search a vehicle, there really is no limit to that, and that would not comport with the Colorado Constitution or the United States Constitution.
Would it be enough for reasonable suspicion to conduct the dog sniff?
I don't think so. And if I remember correctly, I don't think that the McKnight court found that that was enough reasonable suspicion either. Moving to the absence of smell. So the Colorado Supreme Court in Zuniga found that the heavy odor of raw marijuana was a fact that could, under the totality of circumstances, be considered in establishing probable cause. So I don't think the state can have it both ways. I don't think that the smell of marijuana and the absence of the smell of marijuana can both give you probable cause to search. It's one or the other, and the Colorado Supreme Court has said that it's the heavy odor of raw marijuana is something that you can consider. So touching again on Zuniga and Cox, those 2 cases deal directly with the impact of Amendment 64 on search and seizure law in Colorado. And if Zuniga and Cox, if the Colorado Supreme Court in those cases thought that Amendment 64 did nothing to change the state of the law, those courts would have just said there's a dog, he alerted, probable cause, and would not have had to resort to this exhaustive totality test that it engaged in. So if marijuana is not contraband, Zuniga and Cox would have been very short opinions that just said the dog alerted, that's enough for probable cause. So those cases do indicate that Amendment 64 changed the state of the law in Colorado. So the Attorney General argues that Amendment 64 sends a muddled message. I think the voters were extremely clear in enacting Amendment 64. The language says that in the interest of the efficient use of law enforcement resources, enhancing revenue for public purposes, and individual freedom, the people of the state of Colorado find and declare that the use of marijuana should be legal for persons 21 years of age or older and taxed in a manner similar to alcohol. They also said that notwithstanding any other provisions of law, the following acts are not unlawful, and that includes possession of under an ounce. So I don't think Amendment 64 could have been clearer. Voters in Colorado did not want their tax dollars being spent on enforcing marijuana crimes. So I think Amendment 64 put law enforcement on notice that searches for marijuana were no longer acceptable under the Colorado Constitution.
Let me interject. Did Amendment 64 address searches?
I believe my counterpart's representation that it did not. I don't see why it would need to. It said that marijuana is legal. Why would it need to separately address, no, you can't base searches on something that's legal? So I think that would have been practically superfluous to say, that you can't base a search on a legal, constitutionally protected substance. The Attorney General also says that, going to his good faith argument, that there was not misconduct and it was not flagrant. And I'd like to counter that point by just talking about some of the policy implications of what dog sniffs actually entail. So in this case, there were 4 officers that showed up, a big dog. If you're scared of dogs, that would be frightening. And it's a very invasive search. It's not a minimal, minor inconvenience. You're pulled off on the side of the road for up to a half an hour while police officers go through everything in your car, pull out everything in your truck, in public, in front of everybody, looking through everything in your car. So this is not a minor inconvenience. And if we think it's acceptable to base such an invasive search off of the presence of a constitutionally protected substance that many Coloradans possess, the potential for abuse is rampant. There really would be no limit. And I don't know that there would be a limit then to not train dogs on alcohol either, just to make sure that that possession of alcohol is complying with the law, because possession of alcohol can be illegal in many circumstances as well. For the reasons argued in the brief and here today, I respectfully request this court to vacate Mr. Camilletti's conviction, or in the alternative, remand for a new trial.
Thank you, counsel. Thank you both for your really fine arguments. It was very helpful to the court. The case will stand submitted and an opinion will issue in due course. As I indicated, we only have one case on the docket this afternoon, so the court will now be in recess and the bailiff shall so announce.